Good morning, everyone. Can you hear me okay? Everybody can hear me okay? I think we're going to start this program. And first, I want to tell you how honored I am and so delighted I am to be able to welcome you to GW Law School this morning. For those of you that do not know me, my name is Rosa Celorio. I actually serve as Associate Dean for International and Comparative Legal Studies here at the law school. I also teach at the law school. And this is such a wonderful day for us, because a lot of what we do at the law school is actually foster and promote educational experiences. And it's amazing to be able to host this incredible delegation today to actually promote UK and US collaboration and knowledge. So we are really, really grateful for this opportunity today. And I wanted to tell you that another thing that's happening this morning that's incredibly exciting for us is that we're talking about artificial intelligence, we're talking about the metaverse and the practice of law. This lecture is going to be led by Dan Jasnow, who's seated next to me, and I'm going to introduce him for a second. But it's absolutely wonderful to have these educational exchanges, especially focused on issues that are looming large, in the life of the law school, in the life not only in Washington, D.C., but also in the United Kingdom as well. So welcome you this morning. And I actually want to introduce our speakers today because we're very honored to have Dan Jasnow here with us. He's a partner at Aaron Fox Schiff, where he co-leads the AI, metaverse, and blockchain industry group. We say that's the toughest job in the world right now. He has been at the forefront of the AI, metaverse, Web3, and blockchain innovation, drawing on his experience as in-house marketing counsel at Meta Reality Labs, formerly Oculus, where he advised on next-generation consumer electronics and AR/VR software products. He's a top legal advisor in emerging technologies for global fashion brands, sports teams, athletes, media companies, and creators, and provides innovative business and legal strategies. And I also have the honor of introducing, a justice of the Supreme Court of the United Kingdom, which is something that we don't have every day at the law school. So we're incredibly excited and giddy to have you with us today, Lord Lloyd Jones. It's an absolute honor. And I don't think he needs an introduction because he's such a well-known figure, but I'm just gonna say that he's a very well-known British judge and legal scholar. He has served as Justice of the Supreme Court of the UK since 2017 and has also served as a member of the Court of Appeal of England and Wales and as a chairman of the Law Commission prior to joining the Supreme Court. He has a very long bio. Like I could read for paragraphs, Oh, I could go on, right? But we're going to have an opportunity to hear from him later today as well. And thank you for being here. And before passing the microphone to Dan, who's going to enlighten us this morning, I just want to say a lot of thank yous, because the hosting of this kind of delegation and this event really requires a tremendous amount of work. So I want to thank first Professor Leah Calabro, who's actually sitting back there. She's one of our international law professors. She's absolutely fantastic. She made this possible for us, so I'm incredibly grateful, and I recognize your work today. Seated next to her is also Jingxi Dai, who worked hard on this event as well, and also Angelina Bonilla, who should be sitting in this room as well, who from our end made this possible. And I also want to salute a number of people. We have Kath, who's here, Kath Bygrave, who helped us a lot in the organization of this event. We also have Cindy Dennis. We also have Oliver Munsey, who made all of this possible for us. And I'm very sorry if I'm missing anybody from the thank yous. We are very grateful this morning. Without further ado, it's incredible to have you here. Remember that we will have a lecture here until noon, and then afterwards we're gonna have a lunch in the 5th floor of the law school in our faculty conference center. But in the meantime, we're gonna hear from Dan Jasnow. Thank you all for being here today.
All right, can you all hear me? Okay. Great. Thank you all. Thank you to the Society of the Middle Temple for having me. Thank you to Dean Solorio and to all the GW Law School faculty and staff, and for everybody for being here to talk about what I think is a really pressing and urgent question about emerging technology, its impact on the practice of the law, as well as its impact on our existing intellectual property and other laws and regulations. Dean Solorio gave a little bit of introduction, but we have some law students here. Show of hands, maybe. Yeah. Just to give you an idea, to give you a little bit more background. So I started as a summer associate at Aaron Fox Schiff. My background is in what we call soft IP here, so trademark and copyright. That's what I started doing at the firm. I also did quite a bit of advertising and marketing regulations. I am primarily what we call regulatory lawyers, so I do a lot of counseling, not a lot of litigation for the litigators in the room, but we do a lot of sort of long-standing relationships with clients where they come to us with questions that they might need a second opinion on. We help them protect their intellectual property. We help them deal with mitigating risk and disputes. And so a lot of the emerging technology questions that I deal with in my practice and that we deal with a lot as an industry group at Aaron Fox Schiff are helping those clients think through what the implications are going to be of incorporating these new technologies into a new marketing initiative or into a new business process or anything like that. So that's really the perspective I come at it from. And getting to this point, people ask, how did you get into this area? It's really just IP, marketing, helping businesses think through risk, mitigate risk, and then applying that to industries where these emerging technologies are really critical. Also just say quickly, the industry groups at Aaron Fox Schiff are sort of a unique thing that we have. They are multidisciplinary groups of lawyers from different legal practices. So obviously I come at it from the IP standpoint, but we have lawyers from securities, tax, corporate, commercial transactions, venture capital, and we all get together about once a month. There are about 40 of us and talk through how these issues are impacting our clients, what we're seeing in our practice, and and track the legal issues and the developments. Hopefully this works. There we go. Okay. So quick agenda. First, I'm going to do a little overview of how we got here in terms of the entering the metaverse and then generative AI. Then I'll do a brief overview of some of the legal issues and how I think about both the metaverse and Gen AI. And then we've got some hypotheticals, and then we will do some Q&A at the end. Okay, so how we got here. October 28th, 2021, while I was working at Facebook at the time, Facebook rebranded itself as Meta. You may remember that. There was a big announcement from Mark Zuckerberg. Shortly thereafter, interest in the metaverse, although it wasn't new at the time, it actually had been in discussion from the early 90s, but discussion about the metaverse spiked, went through the roof. Interest in it went through the roof, with the height of it being right around when Facebook changed its name to Meta. Just over a year later, AI took all of the air out of the room. So we had the release of ChatGPT on November 30th, 2022. It became the fastest growing user base in the history of the internet. It reached 100 million users in just about 2 months. And shortly thereafter, I don't know if you guys are familiar with The Simpsons, but every metaverse expert shortly became a generative AI expert. But the question is, and I think the way that we think about it, the metaverse, these technologies are here. They've been unpacked, the genie's out of the bottle, and we are seeing companies in our daily practice, legal practice, utilize these technologies in different ways. And in fact, in a lot of ways, they are very complementary. The generative AI tools that we're seeing today are being used and can be used to create more robust and richer immersive experiences, digital experiences like the immersive worlds that are characteristic of the metaverse. They can also be used for gaming, for all sorts of different things, for creation of generative digital art. We're seeing a lot of overlap in these technologies. And I think as we see new technologies like the Apple Vision Pro, which they announced a couple months ago, coming early next year for the low price of $34.99 per set. We will see a continual progression, even if it's not at the wide consumer adoption. We'll see a continual progression of these technologies and merging of both the immersive capabilities, augmented reality that we associate with the metaverse, with the generative capability of these Gen AI tools. So as I said, we come at this from the premise that these technologies are here to stay, and they're very complementary. And so, I'm not necessarily here to be an evangelist for these technologies, but what, I think of it as, how do we help our clients utilize these tools that they're already utilizing? And as a practitioner of IP law, where IP is often the most valuable asset of our clients, it's critical that we have an understanding and that we can be there with them as they explore how to utilize these technologies and put them to good and valuable use. So what is the metaverse? So the metaverse is many things. I think of it as the immersive internet. Some people say it's the successor to Web 2. Imagine everything that you have on your phone in your pocket could be in front of you or around you utilizing some sort of wearable device, whether it's a watch or a headset. It's virtual and augmented reality. Virtual reality being the immersive one where you're sort of in those headsets and you're completely cut off from your surroundings. Augmented reality being something beyond that, where we are combining, bringing together the digital and the physical in the same space. A key part of the metaverse, especially for our clients, is digital goods and services. We'll talk about Nike as one example, but this is a huge market for a lot of people, especially for the Gen Zers, for younger millennials. You see a huge interest in digital goods as being equivalent to or even better than physical goods. When you combine it with sort of concerns about sustainability or waste, we're seeing that some younger consumers would rather have the digital version because they can flex, as they say, the luxury flex. They can have a Louis Vuitton bag, but they don't have any of the physical waste associated with it. And it's sometimes Web3. This is, gets a little technical, but many of these metaverse experiences are built on blockchain technology, which essentially, I'm not going to get into all the sort of technical aspects of it, but it allows for more decentralized control of these platforms, and you can compare it to a Facebook. So if you're a company that creates a Facebook page, that whole experience, that digital experience that you are using as a company, is completely controlled by Meta platforms now, formerly Facebook. They can take down your content. They own the page. They own the underlying software. They can censor it, whatever. In a blockchain-based experience, the brand or the user ultimately has a lot more control over the experience and has more of a true property right to the digital asset. So more like you own the Facebook page than you do in sort of the Web 2 or social media version of the digital experience. So that's one definition of the metaverse. This is maybe how some people see the metaverse developing. This is a video from Adobe, a software company. You can see in this example, this woman wakes up, she reaches for her glasses, she puts them on.
There's been an update to your calendar.
Music for her.
Show
they
calendar.
Display her calendar to her. She has her little, virtual puppy, and it, essentially does exactly what I was saying, which is that it combines what you have in your phone, which you're probably looking to your phone for every morning. It just brings it right into your immediate physical surroundings.
There's an accident ahead. Should I show you an alternate route?
Utility, or some might say distraction and hazard to your life. That's a future version. I don't think anybody says that experience currently exists, although some people do think that the Apple Vision Pro and currently the Quest devices from Meta, as well as potentially the HoloLens devices, which were from Microsoft, are aspiring to create that experience. And we'll see if the Apple Vision Pro can push the ball forward. But certainly that is that, what we just saw in that Adobe video, is I think, a very clear endpoint for what Apple Vision Pro is pushing for. What we have today is really specific applications and platforms. So when we talk about the metaverse in the context of immersive worlds, you have Fortnite, which is a very popular video game. It hosted a concert a couple of years ago for Travis Scott that 50 million people watched. So, it's easy to dismiss these, I think, especially if you're not in gaming or anything, as something smaller. But another, interesting data point is that video game spending recently surpassed, I believe it's all of film and music revenue combined in this country. So gaming is a huge market, and it's a very persuasive market. So we have Fortnite. That's the traditional sort of video game model. Decentraland and the Sandbox are two of these blockchain-based Web3 metaverse platforms. They're more at sort of the cutting edge of the technology. They're where we've seen a lot of experimentation, and they're also where the IP issues become a bit more complicated. What we've started to see in the last few months is brands developing their own metaverse experiences, so their own immersive worlds, essentially gamifying their entire marketing or commerce presence into their own, walled garden of a digital experience. As I said, they generally come in two forms: on-chain or off-chain, on blockchain or off blockchain. And there's a notion that at some point these platforms might become interoperable, which has a huge bearing on what the value is of the digital property in these platforms. So for example, there are companies, major fashion brands, Gucci for example, that are selling a lot of digital goods in these platforms. They might sell what's called a skin in Fortnite that is a branded Gucci authentic item, digital of course. And if, for example, you could take that Gucci digital item off of Fortnite and use it in a different location, in a different metaverse platform, you could see how that could start to accrue additional value, particularly when you then take it outside of these, the several walled gardens, the Decentraland, the Fortnite, the Horizon worlds, and start thinking about it in the augmented reality fashion, where you have Apple Vision Pro, so you've got digital that is layered over your physical surroundings, and then you have your digital Gucci item that you can, use in your physical presence as a digital item. You can just sort of see the technology starting to stitch together a more valuable digital ecosystem, which a lot of brands are already taking advantage of. So Aaron Fox Schiff proudly became the first major law firm to open an office in the metaverse. We opened this office in Decentraland. This is our fully immersive experience there. Gucci has also been a leader in this space. A lot of people say, why did we do this? Do we have client meetings there? And of course the answer is no. But we thought it was very important to get our hands dirty in the metaverse, to figure out what does it mean to purchase land. And you do make a purchase. These are transactions that are enforceable, create enforceable property rights of a digital parcel in a blockchain-based platform. For those that are familiar with the technology, each parcel of land in Decentraland is associated with an NFT. So you purchase the NFT, it gives you rights to the land. And we do, sort of as I was talking about before, for the most part, control this parcel. We can develop on it as we want, subject to some minor restrictions that Decentraland imposes. We can collect data from visitors to this. And it also caused us to experiment with transactions and cryptocurrency and on blockchain. And we also had a ton of clients that were already there. So we wanted to be able to say, to our existing clients that were there, we understand this, we've gone through this, we can help you navigate this process as well. Decentraland has also hosted in the last 2 years two digital fashion weeks, virtual fashion weeks, metaverse fashion weeks, where there's been a ton of activity from Vogue to Gucci to Nike, Adidas, lots of brand activity. And everybody's sort of sandboxing. Everybody's, it's not a perfect experience. It's not getting 100 million views, but everybody is sort of in there, playing around together and trying to figure out what is the utility of this technology that we might be able to pull out of this or build upon. So those are sort of the immersive experiences. Now I'm going to talk about 2 examples of how we are, I think, really seeing some transformative and really valuable uses of this technology. The first one is Starbucks Odyssey. This is a partially blockchain-based program, loyalty program that launched in December of 2022. It's built on the very successful Starbucks loyalty program. I don't know how many of you are Starbucks fans, but if you have the Starbucks loyalty program, you can preload funds into it. You get all sorts of benefits, points, et cetera, for free goods. This is sort of like that on steroids. So every user of Starbucks Odyssey can acquire, or they can purchase or earn what Starbucks calls stamps, but what are in fact non-fungible tokens, which are blockchain-based digital goods. Holders of the stamps can unlock various both digital and real-world experiences. So you get enough points and stamps, you can potentially get a trip to the Starbucks coffee farm in Costa Rica. You can also do fully virtual immersive experiences like a virtual coffee tasting with some of their coffee sommeliers. Not so much the tasting, but talking about tasting notes. You also get, you can unlock free goods, everything from the very basic, like get a free coffee to very significant like these trips. And meanwhile, Starbucks lets consumers sell their stamps to each other. And of course, Starbucks is taking a royalty on all of those sales. They're all automated on the blockchain, so it's a new revenue stream for them. And it also has immensely deepened the loyalty, or what they call the stickiness, of the consumers that they already have in the loyalty program. So one key difference here is that this is not, they're not saying, buy our NFT, it'll make you $1 million overnight. They're basically giving away, for the most part, these NFTs. You buy 3 coffees, you get an NFT. They have very little or nominal financial value, although consumers can sell them to each other. What they do create is a new data stream about the consumers that are holding these items, and a new reason for consumers to deepen their relationship with the brand. Another industry leader is Nike's .swoosh platform, also launched within the last year. Nike has been a leader in the NFT and metaverse space for a long time. They've experimented with a bunch of different platforms, including Roblox, which is a very popular video game, which shows sort of the progression. You can start with these traditional sort of gimmicky, gamified platforms, and now they've built something very, very sophisticated. .swoosh is also NFT and blockchain based. So every participant, and there was a waiting list to get into this, every participant gets what's called a soul-bound token, which is an NFT that can not be transferred. So this is mine. I got into this program, and that is only associated with me. And what that really is a stream of data, again, about me that Nike is getting that will always be associated with me and is can't be deleted. You can't delete anything from a blockchain, and it's permanent. And anything that I do there with this NFT or in .swoosh is going to be collected and stored, recorded on the blockchain under this token ID. The other interesting thing about this is that Nike is allowing consumers to experiment with creating Nike-branded digital goods. So you can create digital Nike sneakers as a consumer. And that, from the perspective of an IP lawyer, is really fascinating to me, because that, in most cases, a brand is saying, I'm going to license you, let's say, on Facebook, a very limited right to use my very valuable Nike IP. You can't take it, you can't commercialize it, you can't do this, you can basically only show a picture of it. In this case, Nike is allowing consumers to come in and to modify virtual designs, and then potentially to mint those designs as NFTs. So create a permanent record of these custom, one-of-a-kind digital sneakers. And then in some cases, they're allowing the consumers to ask Nike to produce physical versions of these goods. So you have this very deep relationship now with a very engaged group of consumers who Nike is licensing not only rights to modify Nike's very valuable IP, but also to commercialize it, to commercialize the rights in the digital goods, and to create physical goods subject to Nike's control. So, a lot of really interesting things happening. And then the third piece is that they've just announced a major partnership with EA Sports, one of the biggest video game makers, where, and we were talking about just a minute ago, interoperability of the metaverse, these worlds coming together, being stitched together to create additional value. These .swoosh assets that you can create on Nike are now going to be able to be deployed in EA's sports games. So you can now wear your custom Nike virtual sneakers when you are playing as Tom Brady in Madden football. So each one of these things is at the end of the day, it's a potential revenue stream for these companies, particularly for consumers who don't care that much about the physical quality or about the physical good, and it's a data stream. So what are some of the legal considerations? One of the biggest ones that we've seen a lot of activity in is the trademark protections. So if you're Nike or Fila or any other apparel company, you probably have registrations in Class 25, which is for clothing, footwear, headwear. But do those Class 25 registrations cover digital versions of that? Some might say yes. I would say they should. But to be safe, everybody's also been filing in Class 9, which is downloadable virtual goods. So, rethinking really from a fundamental standpoint whether or not your existing IP portfolio protects virtual or digital versions of your core goods and services. Another piece that I think has been as responsible as anything for tamping down some of the growth in this area has been financial securities risk. The U.S. Securities and Exchange Commission has been extremely aggressive in bringing enforcement actions against not just sort of the crypto piece. You may have noticed we barely talked about crypto at all, and that's really not an area that I practice in. We do some of it at the firm, but our area is really in sort of the helping brands implement NFT technology, blockchain technology in these sort of marketing initiatives. Most of them are not using crypto as per se. But the SEC, in addition to its very public, well-known enforcement actions against various crypto companies, has been very aggressive, specifically targeting non-fungible tokens. That was an area where a lot of people thought there wasn't going to be as much risk because people were not necessarily using them as an investment contract. But the SEC has singled out a number of situations, including this very famous collection, Bored Ape Yacht Club, and also the NBA's NFT platform, Top Shot, to say these non-fungible tokens, even though they're one-of-a-kind, unique items, you are making promises of future gain when you are selling these, when you're marketing them, and therefore these are unregulated securities. So even in a situation where a client might have no interest in selling NFTs, maybe they just want to give away NFTs in order to engage their consumers, we're still seeing a lot of hesitancy from companies to engage in this space at all because the SEC has been so aggressive in enforcement. So that's definitely put a damper in this area. I think, we'll see, this is going to play out, and I think we'll get some clarity over the next year, 2 years, 3 years about the difference between a true investment contract, a security, or a commodity, and non-fungible tokens that don't actually share investment contract characteristics. Okay, so that's a whirlwind tour through the metaverse. We're going to now dive into generative artificial intelligence. And again, I think it's really important to consider that these are two sides, I think, of essentially the same coin. On the one hand, you have technologies that are creating robust digital experiences, immersive experiences. On the other, you have a technology that is incredibly powerful at building, creating digital content. So you can start with a seed of a virtual world, say something that was rendered by hand, or even just like a hand drawing, or maybe something that a video game programmer created, a very small sort of seed of a world, and Gen AI can blow it up into an immersive digital experience that you can never get to the end of. So and again, think about the gaming, how valuable the gaming industry is. This has incredible implications for that, as well as many other industries. And this technology is going to be here. It's already here, but it's going to be integrated into everything you do, everybody in this room does, in the very near future. ChatGPT, as I said before, has 100 million active users, had 100 million active users in 2 months. But more importantly, Google is adding generative AI tools to its workspace tools. So that's Google Docs, Google Sheets, and Microsoft is adding Gen AI tools to its Office suite. So when you hear people say, well, let's take a pause, let's not use Gen AI, it's here. It's going to be in all of your documents very shortly. Meta is also doing this. Apple is likely going to have something in 2024. And Westlaw Nexus, Westlaw and Lexis are integrating they've already built a Gen AI research tool that is extremely powerful. You can already purchase it. It's extremely expensive for a law firm, but it's already there, and it's performing Gen AI-based research tasks. The other thing about this is that these tools are increasing at unbelievable speed. Their capacity is incredible. If you've played around with ChatGPT 3.5, as many people do, especially if you don't have a paid subscription or an enterprise subscription to these tools, you might have found it's a little clunky. Maybe it doesn't do that good of a job. I can tell you, GPT-4 is phenomenal. It is. I often say, and it's reflected here, that it's the best first-year associate we have at the firm now. And you can see from 3.5, it didn't pass the bar. It was in the 10th percentile. For 4, it's in the 90th percentile. Same with the GRE, which is the graduate school exam, quantitative and verbal and writing. These tools are very, very powerful. And I think we have to reconcile with the fact that these are here to stay. This shows sort of the reactionary response that we've seen when very dumb lawyers are doing some very dumb things, which is just asking ChatGPT to create an entire brief, not fact-checking it, not knowing what they're submitting it to court, and of course they're getting in trouble. You cannot assume ChatGPT is preparing things that are ready for submission, just as I would never assume that a work product from a first-year associate, sorry to the law school students, is necessarily ready for prime time. I would, most of the things that I give to a first-year associate, I already know the answer. I know what I want to see. I know, what I think it needs to, I know the final form it needs to be in. I just want somebody else to do it for me. And I want to train, I want to train the first years as well. But same with GPT-4. So, I have asked GPT-4 to write, draft letters, to draft emails on particular areas of law, something like, draft the opening paragraph on this particular aspect of advertising law, this FTC regulation, substantiation requirements for this type of advertising claim. And, again, most of those cases I already know what the answer is, and it does a pretty good job. I take that, I modify it, I put it into the final document, I cite check it, whatever it would be, but there's real value there, and it makes it clear that these tools are definitely coming for tasks that are performed by everybody, not just blue-collar jobs, a lot of white-collar jobs, and a lot of white-collar tasks. So I think for those of us, for lawyers, you have to be thinking, especially for a young lawyer, you have to be thinking, what is the value add that you bring to the firm? It's not just basic research and writing. You need to be able to. There's still a significant gap between what ChatGPT can produce and what a very good lawyer will produce. And to me, that makes it even more important, and it makes it even clearer when lawyers have the critical thinking skills, the really sharp writing skills that make legal work really important to clients and that make certain humans really stand out from the technology. And that's really important. What we think is not the right lesson is to just say, let's ban the use of this. That's not practical, it's not possible, and it doesn't teach people how to adapt to these technologies, which is really essential as we move forward. And this is another data point on that. AI can add value. This is from a very recent study from Boston Consulting Group, which is a very prestigious consulting group in the US, and Wharton. Wharton has a really incredible researcher, for those who want to nerd out about generative AI, named Ethan Mollick, who produces a lot of interesting work on this. They evaluated 18 different kinds of tasks done at elite consulting companies, and they found that consultants using ChatGPT-4 outperformed those who did not, and by a lot. Consultants using AI finished 12% more tasks on average, completed tasks 25% more quickly, and critically produced 40% higher quality results than those who did not. So, certainly for, Aaron Fox Schiff, we look at this and we think we have got to change the way that we are practicing. We've got to be better about distinguishing between the types of tasks that a lawyer needs to do and the types of tasks that ChatGPT can do. We need to be thinking more about how we can offer value to our clients, particularly in an area like IP, where there's tremendous downward pressure on costs, where people have very expensive, global IP portfolios, trademark maintenance costs. How can we better service our clients by thinking how we can responsibly deploy these Gen AI tools to reduce our own costs and to pass some of those savings on to the client and to allow all of us to do more substantive work. So before you start doing any of that, you really need to know what it is you are dealing with. And the risk factors for Gen AI tools are highly variable, depending on the various use cases that you are considering implementing the tool for. So the risk factors for a text-based tool like ChatGPT, where you're prompting it with a question, you're saying, hey, ChatGPT, write a blog post for me about the upcoming Copyright Office rulemaking on Gen AI. That's going to be very different than if you are saying, hey, ChatGPT, or hey, Harmony AI, create a song for me inspired by Beyonce that is about my 39th birthday. The risks there, just from an IP standpoint, very different. You got publicity concerns if you're talking about music or film or video or images. You have a lot higher copyright infringement concern if you're talking about images. And then a lot of people, one of the most popular use cases is for as coding assistants, computer coding. And that raises another very unique risk, which is the potential integration into proprietary code of open source code, which essentially, there are, I don't know if anyone's a coder, but I don't want to get into the technicals of it, but there are these huge libraries of open source code that everybody sort of picks from and borrows from. They usually come attached to an open source license that the terms of the license convey. So if you use the open source code, you have to convey the open source licenses. If you are inadvertently incorporating some of that open source code into your, say, very valuable patented software product, it can have major implications for the patentability and for your ability to protect it. So these are all things that you really have to think through before integrating any of these things into your business processes. The other aspect that you want to consider is that the legal risks vary by the component of each of these tools. And you can really divide them into three buckets. Each Gen AI tool, for the most part, has a data set which may or may not have been compiled by the entity that builds the machine learning models, which is the real thing that does the processing. The data set take, for example, an image Gen AI tool, consists of hundreds of thousands, maybe millions of scraped image files from the internet. For ChatGPT, which is primarily text-based, it includes millions and millions and millions of pages of text. For music tools, it's not just scraped music files, it's information. They're much. I think the music case is really interesting because it's a much more involved process, but it requires. Often these data sets are the result of somebody sitting down and compiling metadata about various songs, like the frequency of the song, the length, the written lyrics versus the spoken lyrics, the tone, all these different things that go into it. And then there's the machine learning model, which is sort of the heart of the software programming, the engineering. That studies the data set, and it learns how to produce these outputs. The output is what you get when you ask the GenAI tool to produce something. So data sets, if you have a client that's doing that, you're thinking about infringement. So do you have the defense of fair use under US copyright law to be compiling all this information, particularly to the extent that it includes copyrighted works, which it almost always does? Do you have a fair use defense to be using the works in order to create a data set for a machine learning model? The legal answer has been most likely yes. You do have a fair use analysis or a defense there. But we've never tested that fair use defense in the context of these tools that are capable of creating massive amounts of directly commercially competitive works at scale. So, is it truly fair use to use copyrighted song catalogs to produce massive amounts of songs inspired by that copyrighted catalog that consumers can then listen to without paying a royalty back to the original artist? I don't know. I think that's something that needs to be tested in the courts. But so you have all those questions. You have the collection, the vacuuming up of potential consumer PII, personally identifiable information in these data sets. If you have a client that's doing machine learning models, you of course want to think about patentability. Can you protect the underlying software product there? And what safeguards are you putting in place to make sure that you're not going to incur significant liability as a result of whatever this machine learning model is doing? Output. If your clients are using the output, which is most of the use cases that we're seeing right now, do they have an infringement risk? Do we know, first of all, what goes into the data set? Some data sets now we're starting to see are promoting themselves as being infringement proof because they're only using their own content. Adobe Firefly's AI tool is, I think, the leader in this space. They say, our data set includes only our own content or public source content, so we will indemnify you for any claims of potential IP infringement because anything we produce, it's not going to be infringing. Most of these tools are not doing that. You don't know what goes into the model. The models have third-party content, and they produce content sometimes that looks like the original. So you have no real predictability about the potential infringement risk from the output. And obviously there are ethical and professional duties that you have to consider when using these tools. So if you focusing in on the data sets of those three buckets, we are already seeing a ton of litigation in this area. Sarah Silverman, who's a well-known comedian and author, and various other authors, Michael Chabon, a very well-known novelist you might know, filed another lawsuit just like 2 weeks ago, saying that the use of their works in these data sets to train AI models is an infringement of their works. Getty has done something similar for a photo data set. Coders, the open source coders that I was talking about a minute ago in the coding context, have done something similar to GitHub Copilot, the most widely used coding assistant. And then there are consumer class actions alleging major violations of privacy rights. These are all interesting cases. In my mind, a lot of them suffer from major weaknesses, which is that we still don't always know, and in many cases we don't know at all, what content goes into the data set. So, for example, in the coder lawsuit, they're saying, well, you said you sucked up all code from GitHub, this big online repository of code. And our code is on GitHub. Therefore, you must have used our code to train your model. But there's no concrete allegation in there. And the same thing happens in the infringement case. We know you, OpenAI, have sucked up everything from the internet in order to train your large language model. So you must have used our work. That's one problem. And then there's a second problem, which is that the Gen AI tools don't just copy and paste the works that they're trained on. They produce something original. Sometimes it's less original than other times, but it's not, you don't have a copyright infringement case in the clearest sense. So it's very difficult, I think, for a lot of these cases to make concrete allegations about the harm that they've suffered or that they specifically have had their works infringed. This is an example that's pretty clear, at least that it was, what the source was. On the left is an actual Getty image, and on the right is an AI-generated image, with a lot of sort of the grotesque characteristics, which are quickly becoming a thing of the past. That Getty alleges is a direct infringement. You can also see that the Getty watermark is pretty clear. You can see what it is, but again, there's not clear trademark infringement because it doesn't actually read Getty. So it's an example of just some of the complexity, I think, of what this is, but also of the tool's failure at times to make distinguishably new content. They do sometimes fail, and there have been studies that show that, in fact, there are a lot of instances of infringement. There are a lot of instances where the machine learning models fail to fulfill what they've been programmed to do, which is create something new. In fact, they, a lot of times, are creating something that's too derivative. But that's a programming error, and it's being corrected, and again, we're a year into these tools. So what are the risks to users? We talked about this a little bit, but one of the biggest risk factors is that under current US copyright law, works created by a machine or animal are not subject to copyright protection. They cannot claim copyright protection. So there's a very famous case in the US of a macaque or a bonobos monkey that stole a photographer's camera and took a picture of itself. And then the photographer tried to claim copyright protection in the work, and it got litigated, and the court said, no, a macaque cannot have a copyright in this photo. And it's a great case. I like that picture, but we've sort of moved on from that to now we're in this machine learning model. Same principles apply according to the Copyright Office. So if a machine learning model creates your work, then you cannot claim copyright protection in it. There are sort of two sides of that. One of them is the most common use case with these Gen AI tools is that you have prompters, so people that are instructing the Gen AI model using a text prompt, what they want the output to be. So I could say, Midjourney, create an image of a hippopotamus eating a pepperoni pizza. And so it would create that for me. And so I would take that, that example, I would have no copyright protection in that image. But what we're seeing, people challenge this law or this rule are instances like in this example from a graphic novel called Zarya of the Dawn, where the author of the work, the human author, is sitting in front of the prompt and inputting thousands of prompts to create full-length graphic novel images. So she sat there, she said, rather than the hippopotamus eating pepperoni pizza, she's saying, well, I want it to be this color hippopotamus, and then I want it to be, sitting in this particular way, and I want this to be the color palette, and I want, the pizza to be more abstract, and I want this to be inspired by, Picasso, and now I want the hippo doing something else, throwing the pizza. And the Copyright Office has so far in this first test case said, doesn't matter how much prompting you're doing, the Gen AI created that work. The Gen AI did the key work of authorship, and a machine cannot have copyright protection. I think just from a, common sense, perspective, that rule is going to fall. There's no way that that is going to continue to be the rule as Gen AI tools become more and more deeply embedded, not just in all of our technology, but in the creative process. I mean, these open up enormous powerful new tools for creatives, for artists to create new work, and in a way that they are still directing the creative output, just like we don't forfeit copyright protection when a photographer touches up a photograph with Photoshop or creates an image with Photoshop and then maybe digitally retouches it. So that area of artistic expression using Gen AI, so you start with a prompt and then the Gen AI creates it. Doesn't matter how many times you input into the prompt, it's still not protectable. That's one category of potential risk. The Copyright Office has also said that in order to protect something that is created by Gen AI, you might be able to have copyright protection if you substantially modify it. So that's sort of there's the input sort of scenario where you're inputting a prompt into this tool, and the tool is ultimately creating something. And then you have the sort of output modification scenario where you're still asking the Gen AI to create something, but then you're modifying it. In that case, you can potentially have copyright protection, but it's very case by case. And we're seeing very sophisticated uses of this technology in the creative process for a lot of our clients. And so, they want to know, well, have we done enough for copyright protection? Have we done enough? And it's like, I don't know. I mean, there's not really, there's some guidance, but there's not very much. The other piece that can have really significant ramifications for clients is the duty to disclose to the extent that your work, if you are seeking a copyright registration, you have a duty to disclose if any of it was created by Gen AI. In practice, and again, because of the level of sophistication we're seeing with our clients in terms of their creative processes, it's often very difficult to differentiate between what was created by Gen AI and what wasn't. And if the Copyright Office is taking the position that basically anything using Gen AI is not protectable, that creates a really big problem for a lot of clients. And then also in the commercial sort of transactional category, any agreement involving a creative work is going to involve language that says either it's a work for hire and the hired worker, the independent contractor, can convey the copyrights that the employer wants as part of that. That's like a standard provision. Or you hire somebody, you purchase the copyright from somebody who's already created a work. Always, every agreement should say, the seller has the necessary rights to convey the copyrights that the purchaser is acquiring. And this raises all sorts of new questions about, does the use of Gen AI negate that language? Does it lead to a breach? How much Gen AI did you use? What was your creative process? I think, right now we're at a point where we're basically telling clients, document what your creative process was so that if needed, we can go back and we can really defend that you have an enforceable copyright in this work. So another risk to users is, of course, IP infringement. Copyright and trademark are pretty clear and obvious, but what about publicity rights? That's an area where, I think there's, at least in the US, the ability to protect name, image, and likeness is based primarily on or exclusively on state laws, whereas we have federal laws for copyright and trademark, which also means you have easy access to federal courts and, in many cases, statutory damages. Publicity rights are a little trickier to enforce. And it's also the area that there's a high risk of exploitation with these Gen AI tools. As I said earlier, a lot of these models are designed not to infringe copyrights. They're deliberately designed to create new content by learning the patterns of a massive library of content. But they don't usually have similar protections or safeguards that say, don't display the name, image, or likeness of a famous person. So, examples of this abound. This was a real example that we got from a client, an apparel client who said, hey, we want to use these really cool AI-generated fake movie posters and put them on clothing for our new collection. And so they said, what do you think about this one? I looked at this and I said, well, a number of issues, but one of them is that, this actress looks really familiar to me. I don't know if anybody has, what do people think it looks like? Yeah, exactly. So, can they commercialize? You would never, as a lawyer or as a client, commercialize Jennifer Lawrence's name, image, or likeness without getting approval from, her people. So, just because it's made by Gen AI doesn't mean you can do it. And just because it's made by Gen AI doesn't mean that it's going to be non-infringing. You still have to know what rights you're deploying in this commercialized content. So this is a big concern. But it also comes up a lot in the music case and in the film case. So, there was a very famous example recently of a AI-generated song called Heart on My Sleeve, which was made by some anonymous person who entered into a prompt that he wanted a song in the style of the singers Drake and The Weeknd. And this produced a song. He wrote the lyrics for it, so he had a claim to copyright protection of the lyrics, although he put it into a Gen AI voice generator and had it sing the lyrics. But the song sounded just like a collaboration for Drake and The Weeknd. It was uploaded onto Spotify. It got millions of listens. And at the end of the day, those listens, at least to some extent, are cutting into the royalties that Drake and The Weeknd or their studios would otherwise be getting from plays of their songs. And you can do that with everything. I mean, there are tons of songs already out there in the style of Frank Sinatra or in the style of Justin Bieber or Beyonce or of whoever. And those are not, there's not a clear copyright claim for those because they are generally original works. They're all original lyrics. They're usually original songs, so the melodies are all original. But you definitely have a publicity rights claim, I would say. But we don't have a federal publicity law. So you then have to think about what are the tools that are available to the artists in order to protect their IP rights. So best practices for incorporating Gen AI. I said at the top that AI can add value. I think you really have to think of it as responsible and informed use of AI can add value. Otherwise, you really risk potentially jeopardizing very significant and valuable rights of your clients. There are a proliferating number of tools that are out there, but there are some that offer enterprise tools. OpenAI is obviously has a $10 billion backing from Microsoft. OpenAI makes ChatGPT, DALL-E image generator, a number of other big and powerful tools. And Microsoft is offering enterprise subscription access to a lot of those tools. Not endorsing what OpenAI is doing, but when getting subscription agreements, enterprise level of agreements, you can usually mitigate some of the most common concerns like confidentiality and privacy concerns. So an enterprise subscription to ChatGPT-4, they commit to deleting all your data. It's all stored locally. It doesn't get fed back to the large language model to continue training it. So we as a firm have enterprise subscription agreements to OpenAI services through Microsoft, and it all meets all of our confidentiality and data security standards. So working with trusted platforms can mitigate a lot of the risk associated with use. You really need to look closely at the use cases that you or your clients are considering using it for. Make sure that you understand how the technology works and what the legal implications are of that technology. You want to provide appropriate training. Aaron Fox Schiff has trained 140 lawyers on how to use these tools, the enterprise tools. We have an incredible team of technology professionals who are doing trainings in all of our offices, doing virtual trainings, and continuously surveying lawyers about how people are using it and what the use cases are, and looking at the tools that are coming on the market. Learn by doing. I mean, I still think that's a key. It's a key element of all of this. It's what we did in the metaverse. It's what we're doing in Gen AI. You can't advise a client on these tools and technologies until you go in and start learning. And that's, summer associates, junior lawyers are asking me all the time, how do you get into this? How do you learn about all this? And if you don't take the time for these emerging technologies that are very, very rapidly improving to study it on your own time, not on a client's dime, you're not going to be able to keep up and be able to advise your clients on this stuff. So it takes an investment, an interest, a motivation to learn these things and to stay up with the technology and to use it. I mean, you should be playing around if you want to advise in this area with ChatGPT and DALL-E and Midjourney and figure out, a lot of people just don't even know where to go to access these things. And you've got to get over that hurdle, start to understand it, what their capabilities are if you want to advise on it. And then study and adapt. As I said, we routinely survey Aaron Fox Schiff attorneys who are using ChatGPT and these tools to figure out how they're using it. I do this presentation a lot with our Chief Innovation Officer, and I didn't include it today, but we have detailed information on how attorneys are using this, and it's things like draft me this basic agreement, draft me a work for hire provision, draft me a blog or LinkedIn post. A lot of this stuff that in a lot of cases is very low risk. Draft me a blog post or a LinkedIn post on the Copyright Office. That's a low risk situation, and it's something that these tools do really well. So we're going to talk about hypos. I do want to add, there is an incredible amount of activity going on right now in this city that is going to shape the future of these tools, of Gen AI in particular. The Copyright Office right now is soliciting comments about how it should consider and treat works that are created in part by Gen AI. The Federal Elections Commission is soliciting comments right now about how it should think about or regulate the use of Gen AI in political communications. And there is, a rarity for this town. There's some bipartisan efforts and momentum, I think, to regulate Gen AI tools or come up with new methods of protecting intellectual property rights. There's been a lot of calls for a federal right of publicity law in order to ensure that creators, celebrities, artists are protected, that they can enforce their name, image, and likeness in court, in federal court, and that they can take advantage of statutory damages potentially. So I think especially for the law students here, people should get involved. I mean, I think regulation is needed. I mean, this is an incredible, technology. It's very powerful. Even the most prominent voices in the industry, like Sam Altman from OpenAI, are saying, regulate us. This needs to be regulated. This is a really powerful tool. And you as law students in this town can really shape that effort and become involved and just really, that's a great way to understand what the implications of this technology are going to be and what the legal framework is moving forward. Hypos, since we're at a law school. We've got a few lightning round questions. So your client builds a new generative AI model that produces artwork. Notice the client is building the model there. The client wants to file a copyright application for his favorite, I think I used both genders, but that's great, for his favorite AI-generated image and claim ownership in the copyright as a work made for hire under the US Copyright Act. So in this case, the artist created the model, so they built maybe the data set and the machine learning model. They're probably a computer engineer, software engineer, and then they want to say, anything produced by the machine, I should own the copyright in as a work for hire because I own the machine. Can he or she or they claim copyright ownership as a work for hire? Anyone? No? Correct. No, they cannot. And so in addition to the Copyright Office opinion on this, which came in the Zaria of the Dawn case, which was a regulatory decision. This did go up to the Copyright Office in this exact form. I mean, it went up to the DC Federal District Court for the District of Columbia in Thaler versus Perlmutter, exactly on these facts. And this was not a surprising decision. That goes back to the line of cases with the macaque that says you have to be a human in order to get it. And I think this is a pretty easy case. We should be thinking about whether the Copyright Office has reached the right conclusions in these, but in this case, I think that's a pretty clear one. So this is a different one. So your client, a creative agency, is hired by a fashion label to create an opening video sequence for a major fashion show. Through a process of trial and error, a team of 3 people creates a video using Gen AI. They submit thousands of descriptive prompts to the Gen AI tool to refine the video, transforming an initially dull Gen AI video into something that closely reflects the brand image and is worthy of national broadcast. Can the creative agency claim copyright ownership in the video and convey that copyright to their client, the fashion label? What was that? Did you have an answer?
Still a no.
Still a no?
Uncertain.
Uncertain. Seems like we have a mixed audience. Who thinks yes, they can convey the copyright? Who thinks they cannot convey the copyright? I'd say the no's have it. And the no's, for now, I think are what the legal answer is. I think this is a terrible test. There should be some level of human authorship. Question in the back?
Just a question in respect to that. If you are using the brand's image, so for example, Nike,
Yeah.
does that become where it becomes a bit of an issue because the Nike brand itself is copyrightable, but not the rest?
So you'd have trademark rights in the swoosh or the Nike word mark, but the video itself, as the work as a whole, you wouldn't be able to claim copyright protection in. But that wouldn't mean you don't still have rights in the IP that's incorporated into the video. So one more of these. Your client, an entertainment studio, is preparing storyboards for an upcoming animated series. They use Gen AI to produce 3 of the scenes in the storyboards. 2 of the AI-generated images are subsequently retouched in Photoshop. The 3rd is partially redrawn by hand. Can your client claim copyrights in the 3 images? Yes, I'm hearing. Probably. So this is a case that the Copyright Office actually considered. This is also it was the same case. It was Zaria of the Dawn. The artist sought to claim copyright protection in this image on the right because she touched up some of the area around the woman's mouth, and I think some of the shine and maybe the forehead a little bit. The Copyright Office said this was not sufficient to create copyright in the human author. So there is some amount of modification that can transform a generative AI image into a protectable image, but this was not it. Okay, the final. This gets back to metaverse as well. And this is not, this is in line with what we're seeing from some of our big entertainment brands, especially those who work very closely with well-known artists. A musician has decided to issue 500 NFTs, non-fungible tokens, to fans to fund his upcoming album. The NFTs will grant users a variety of exclusive benefits, including early access concert tickets and access to VIP lounges, limited edition signed vinyl records, a share of royalties on future revenue from the record, and access to a digital world, graphics generated by AI, where the musician will host virtual music festivals and offer digital merch. In the virtual world, NFT holders will also be able to purchase one-of-a-kind AI-generated music tracks that are inspired by the musician's voice and lyrics, which they will be allowed to commercialize however they want. They want your help setting it all up. Are there any legal issues that jump out to you? Yes? What? You can just yell them out. But so, broadly speaking, what jumps out to you here?
SEC is going to be all over it?
Yes, definitely. There's an investment contract here. This would almost certainly be considered by the SEC as an investment contract. because of, so a couple things here. Using the NFTs to fund a project, that sounds like a capital raise. You're issuing shares, and then entitling the holders to the royalty stream, just like getting dividends from a stock. So we do see things like this that are lower risk. You can just, so say it's a loyalty program where the musician just wants to reward their closest fans with participation in a digital community where they're going to get all these various perks. Maybe you just give those out. You don't use it to fund the album, but you give out those NFTs on a first come, first served basis or something like that. You could still offer them, all these perks, but you've got to be careful about the SEC piece. Yeah.
The digital merch is going to make the most amount of money, and that's not covered in the startup, so that's a problem to raise.
Yeah, the digital merch might be. The AI generated songs are not going to be copyright protectable. So can they commercialize that? Unclear. At least they won't have a claim to copyright protection. You might be able to, allow them to commercialize it through contract or other agreements that gives them some sort of rights, and you have, rights as the creator or the name, image, likeness that's used with that. But certainly the use of Gen AI to create some of these assets is going to complicate the commercialization.
I'm fascinated by this because I do a fair amount of bankruptcies. Bankruptcy.
I spoke at a bankruptcy conference.
Good. Well, we routinely issue stock in the new company coming out of a bankruptcy, none of which is covered by the SEC. So now, what if I fund some of this coming out of a bankruptcy using NFTs? Will I avoid the SEC regulation?
I have no idea.
Okay. Ponder that.
Yeah. I don't know. There have been, so the use of crypto and blockchain-based digital assets has come up in bankruptcies, especially because we've seen a wave of bankruptcies in the crypto space. I don't know how the SEC piece comes into it. There's some really interesting issues around like the volatility of crypto, and I did speak at a bankruptcy conference, but I'm not a bankruptcy lawyer. But I know that after declaring bankruptcy, some of these companies have seen somewhat of an uptick in the value of the crypto, and that's led to all sorts of complications about the assets and valuations and all sorts of stuff like that.
A follow-up. In one of our cases, we had somebody rob the company blind and then invested in crypto.
Uh-huh.
How the hell do you get it back?
You can get it back, actually. There have been a number of instances where crypto and stolen NFTs have been recovered. It's quite tricky, but there are tools, there are vendors who specialize in tracking on blockchain transactions, which in many instances are designed to be anonymous, but actually, there are all sorts of ways you can track them. And so they track them back to particular wallets. And then we've had, there have actually been cases where courts have frozen digital wallets or issued an injunction on the transfer of crypto funds or NFTs. And so courts are, they're becoming more sophisticated in that, and so are the people that track it for anti-fraud purposes. Questions? Other questions? That's all we have, so more questions if you want.
It's just a question based on a very powerful production we had last night on ESG.
Uh-huh.
Unless I missed it, there was no mention of anything with AI and the environment.
Uh-huh.
And especially as it's a new area and all that, and we're looking at the use of the world to build this new world.
Yeah.
Is there something in there that's going to come to really assist all of us in the environment and how AI will be used in this area?
Well, I mean, AI requires an incredible amount of computing power, which is a huge electricity drain. So that's going to probably exacerbate the problem, except to the extent that these providers are building massive computer farms, network farms, powered by solar power or hydro or whatever it is, whatever renewable source. And we're seeing some of that from some of the big companies. I don't know that Gen AI is going to help with, solving global warming or climate change. It's gonna, I think to the extent that it's very resource intensive, it's going to, be a problem. But, just like everything else, I mean, everybody needs to, reduce or switch their consumption over to something more sustainable.
During your discussion, you mentioned certain brands, and these are world brands like Nike and all the rest. I mean, what are they doing about that? And in terms of the whole, wastage and all that sort of thing, utilization, and how can they consider using AI to help in this?
Well, it does provide, incredibly powerful analytical tools that can help them, analyze wastes and all that. And actually, people are using blockchain to track, sustainable materials. So like organic cotton or cotton that's, grown using less water, less resource intensive. Like we're seeing some implementations of tracking technology on blockchain to make sure that, these things are being tracked as they're going through the supply chain. And a lot of the fashion companies are actually pretty, forward-leaning, not all of them, but some of them are pretty forward-leaning on, getting to net zero or whatever. Yeah, in the back.
Mine might be the lack of understanding of blockchains. When you were saying like there's a lot of information stored within it, is there going to be one of these issues of like the right to be forgotten, like data privacy? Like you say you've got your NFT, and how easy is it for you to get that deleted and your information removed?
Yeah, so in most cases, the information that's stored on chain is non-personally identifiable. So, my .swoosh wallet is associated with a random, 50-character alphanumeric ID. So you wouldn't necessarily know what wallet is mine. There are ways to track, and sometimes people do put, PII on blockchains, and that is not deletable. But a lot of brands are being careful about storing PII on a traditional sort of Web 2 interface and then connecting it to the permanent data is usually anonymized or not trackable. Yep.
Hi, I'm Mariam Hussain. I worked under Amity and Ambassador, and I have a question about the metaverse. So, at least in the UK, it seems that many institutions are getting hacked. Universities, police forces. So, how do you think companies that are wishing to advance the metaverse, what do they need to do to ensure that their users' data is protected?
Yeah. I think it's the same thing we tell companies all the time and that the FTC in the US tells companies, which is privacy and security by design. So if you're building your own platform, privacy and security needs to be your first consideration. A lot of companies are building their own metaverse experiences, which gives them a lot more control. But as a lawyer for some of these companies that are thinking about using these tools, they absolutely need to be thinking about whether the metaverse platform that they are considering using, whether that's their own or a white label version of an existing platform or some public existing platform meets their security and IT standards. In the back?
You talked lots about NFTs, and I think you had one of the digital 8 NFTs that works up short. And obviously there was that huge interest in buying digital artworks and unique, original tweets and YouTube videos. And then a lot of those investments have massively increased in value and sort of gone off a cliff. I'm just interested in why you think that was. Was it a blip? Did it come too early? Or is it an indicator of maybe being a bubble with some of these digital assets?
Yeah, I think it was definitely, was it Lilies or what was it in? Tulips, right. I think it was an investment bubble to some extent that certainly popped when crypto collapsed. And we're not, our clients, big companies, aren't really interested in NFTs as a valuable investment. It also raises SEC questions. what we're seeing now, and I think in the sort of the second phase of this, getting a little bit more mature or understanding of the technology, is really their ability to engage consumers, give them away for free, doesn't even matter what the value is, or allow them to create their own thing that they can, mint as an NFT. And it's a way to collect data, it's a way to engage, and it's a way to track consumer activity. Yep.
So I'm a family law practitioner, so I have to defer to your knowledge on IP, but I was slightly disheartened by your predictions on the Getty Images Stable Diffusion case, because it seems to me that ultimately all the generative AI is highly dependent on what's put into it in order to produce something that is, particularly in a legal context, accurate.
Yeah.
So as practitioners, if we're using generative AI to summarize law,
yep.
I can see if all it's doing is looking at open source law and court decisions. That's fine. But
yep.
The other half of it, of course, is commentary, and especially where the commentary offers opinion on an interpretation of the law. Now, if you just get a summary of the law that relies on that opinion, but it doesn't cite it, that seems to me to have a real ethical problem.
Totally agree.
How is that going to be resolved?
So I think, what we're already starting to see some of is the creation of these data sets that are based on open source works or licensed content. So it doesn't necessarily address the sort of ethical consideration of how much should you borrow from a Gen AI produced content, how much should you use it, particularly in an external facing document. That's a question that I think every lawyer has to just have a sense about. What you can use, what you can't. Are you using something that is conveying some sort of analysis, or are you using something that is summarizing black letter law? What's the nature of the use? Is it for a dinky social media post, or is it for something that's more substantial? But so like Lexis and Westlaw have built a very powerful tool, and it's based on their data set that they curate. So if you have trust in Westlaw and Lexis and can get assurances and maybe contractual protections for IP infringement, then you know that you're in a little better spot. And there are a bunch of there are more providers, and I think we're going to see more data sets that are targeted to specific industries, where they say, okay, we want to license everything that Disney has ever produced, and we will then create a tool for you, Disney, to deploy however you want. You can make a mashup of Aladdin and The Lion King using Gen AI, and Disney will still benefit from it, and they'll be licensing it at the front end, and they'll be commercializing it on the back end.
I mean, is it at the moment, if it relies on copyright material within its reference, does it tell you?
No. I mean, they all do. And that gets to the question of fair use. And there's a good argument that using the copyrighted works to train the model is fair use. It goes back to the early internet cases. There are cases on Google image searching and indexing. Google creating its library of books that it scanned. All line of cases that says that this is transformative. You're not using the copyrighted work to create a replica or to supplant the original. You're using it to create a model, a large language model that produces something originally or completely new. I think it's the other side of the fair use analysis, which is the impact on the original work, the impact on the market for the original work under U.S. law that has to be sort of reconsidered in light of the potential for these works to create directly, or the tools to create directly competitive works.
Do you think Getty will lose?
I don't know if Getty will lose. They've got pretty good evidence, and they're suing Midjourney, I think. It comes down to the data sets, what is in the data sets, and then also what evidence you have of direct infringement, I think. Yep.
Bring it back to law schools.
It's a problem.